Good evening, Tewksbury. It is 6:01 PM on Thursday, January 20th, 2022, and I'd like to call this meeting of the Tewksbury Board of Health to order. We were able to meet tonight because there is a quorum present of in-person members, and then also joining us remotely tonight is Clerk Maria Zeroulis and Dr. Anthony Buschetti. So they're both joining us by phone. On the agenda tonight, we have approval of minutes. We have 3 sets of minutes before us tonight. 2 are monthly meetings from August and October. We did not meet in November, December. Hello? And then we have the January 7th, 2022 Hello? Emergency meeting minutes.
Still me, Tony.
Oh, hey, Maria. Sorry, hon. I put off the mute too, so I wasn't sure what was happening, hon.
No, I still don't know what's happening. I don't know what's happening.
Good question.
I just left a message with Jason.
I'll text.
We can go.
Yes.
Tony and Marie, can you hear us?
Yes.
Yes, can you hear us? We were muted and then we just came on. Yeah.
Okay.
You're okay.
Yes, and we're live.
Yep. Okay, so I just started going over the agenda. So first item tonight is approval of minutes. We have meeting minutes from our monthly meetings in, actually we have minutes from August 19th as well as October 21st. And then the emergency meeting minutes from January 7th. So all 3 sets have been reviewed by myself. I'm not sure if you had a chance to review the January 7th emergency meeting minutes or not, but I had no comments as they were submitted.
I did review them. I have no comments.
Okay. And I think, Bob, you had a question on, I can't remember now, if it was the August or the October.
I think it was the August 19th,
Okay.
and I think most of it was picked up in the 10/21 meeting, though.
Okay.
So I'm okay with the correction of 8/19 and the comments incorporated in 10/21.
Okay. And Mr. Rue, taking the 2 monthly meetings first, any comments or edits to either the October or the August meeting minutes?
I have none. I commented through Lisa. I believe she updated it for me.
Okay. And Tony, any edits to either the August or the October minutes?
Not that I can think of at this point. So I think we're okay.
Okay. So let's just, on the January 7th, 2022 emergency meeting minutes, does anyone here in the room have any comments or questions or edits?
I abstain.
Okay.
None here.
Okay. And on the phone, our dial-in callers.
No.
Okay. Tony, any comments? Okay. So we have 3 sets of meeting minutes that sound like they're ready for approval. If someone would like to make a motion to approve all 3 as submitted.
Make a motion.
I'll make a motion to approve the minutes for August 19th, August 21st, and January 7th.
October 21st.
October 21st.
What did I say? October 21st and January 7th.
Okay. And we're willing to second that motion.
I'll second it.
Okay. So Maria has put forth the motion, and Bob has seconded the motion to approve the minutes for August 19th, 2021, October 21st, 2021, and January 7th, 2022 as submitted. We will take a roll call vote since we have remote participants tonight. So, Mr. Rue, yea or nay?
Yay?
Mr. Scarano?
Yay.
Ms. Cirulis?
Yay.
Dr. Bichetti?
Yay.
Chair votes aye as well, so motion carries unanimously 5-0. So we're caught up except with the exception of last Friday's minutes, so doing good. New business. Since someone decided to get married on us, we have to reappoint special health agents. And so normally we do the appointments in May for whatever reason, and Lisa Hadge had the great question of, why May? So we said, well, let's do it tonight so we can sort of do an annual reappointment at the start of the calendar year. So we have a couple of things we'll need to handle for appointment of special health agents. So first to be Shannon Gillis, appointment as special health agent. And let me just read through these and then someone can make a motion to approve. Ashley Pavlakis, public health nurse, and appointment as special health agent. We'll have you do a quick meet and greet shortly. Vincent Gu, health inspector, who's a special health agent. We'll have you come up to the table for a quick meet and greet as well. And Director Gillis, which I'm getting used to now. Vincent is our new inspector through the grant between Bill Ricker, Tewksbury, and Tingsboro?
And Chelmsford.
And Chelmsford. Okay, perfect. Okay, so we'll take those three first. Since they're all, two are new and one is a renamed director, which we'll have to redo. If someone would like to make a motion to approve all three as special health agents.
I will make the motion to approve Shannon Gillis, Ashley Pavlakis, and Vincent Gu as special health agents.
Okay, and we're willing to second the motion.
I'll second the motion.
Okay. So Maria's put forth the motion. Mr. Scarano seconded the motion to approve Shannon Gillis, Ashley Pavlakis, and Vincent Gu as special health agents. We'll take a roll call vote. So we'll start with members present. Mr. Rue?
Aye?
Mr. Scarano?
Yay.
Ms. Cirulis?
Aye.
Dr. Bichetti?
Yay.
Okay, chair votes aye as well, so motion carries unanimously 5-0. So why don't you two come up to the table? And I know, Ashley, you would introduce yourself on our January 7th WebEx, but we'd rather you be able to do it in person as well, so
Absolutely.
floor is yours.
Thank you for that. My name is Ashley Pavlakos. I'm coming to you guys from my past experience. I worked in the emergency room, and I did that for about 6 years. Been a nurse for about 8 years now, and I look to bring all my experience and knowledge that I have to this job and to help better the communities that I'm serving. So thank you for having me.
Okay, and for the benefit of the residents,
Sure.
what is your schedule in town? Because you're a shared resource.
Absolutely. So I am currently splitting my time between Tewksbury and Tingsboro, predominantly mostly just Tewksbury though. And it's most Mondays I'll be at Tingsboro and the rest of the week I'll be here.
Okay. And are there certain hours that you're trying to be here?
Yes, so I come in at 8 and I work to 4:30
Okay.
on all the days.
And for residents that have not come to town hall in a while since COVID times,
Yes.
the town nurse's office has been relocated early this year. So where is your office located if they come here searching for you?
Absolutely. So if people come to town hall, I'm on the lower level of the building, and there's an office right as you come down the stairs there, and it is labeled public health nurse.
Okay. And if I remember correctly, for those that have historic memory of town hall, that used to be a conference room downstairs, correct?
Yes.
Okay. So if anyone's looking for that conference room, it's now the town nurse's office.
Thank you.
Okay. Welcome aboard. And Vincent?
Hello, everybody. Like my colleague here, Ashley, my time will be split between Tewksbury and Tingsboro. I'm mainly based out of Tingsboro. I graduated college from UMass Amherst in 2019. Prior to being a health inspector currently, I worked for a private consulting company, mainly working with asbestos, indoor air quality, and monitoring projects involving hazardous materials. I'm happy to be here and serve the municipalities.
Okay, perfect. And then, not to put you on the spot, but I'll ask the director. I know we've been talking, because one of the things on our agenda tonight is the food safety or food establishment regulation, and part of that was looking to require that someone on premise at all times during the preparation, cooking and serving food, and the cleanup afterwards be ServSafe certified. And we talked, might be good if we're doing this to try to offer ServSafe training to folks. So is this something that Vincent will be able to help us in, or is he going to be more on the inspection side?
Yeah, so I had a meeting today with the grant, and we all discussed this actually, and I know a couple of the communities were interested in doing that as well, and that would help with Vincent's deliverables as part of the grant. So that's something we're going to be looking into in the future.
Okay, perfect. And we did not rehearse this. I was not aware you had that meeting today, so that was good timing. Any questions from board members of either Ashley or Vincent?
I have none.
Okay,
Nice to have a Yumi on board. Class of 76 here.
All right.
1976.
We were thinking 1876, Joe.
and from the dial-in callers, Maria Rattoni, do you have any questions for either Ashley or Vincent?
Nope.
I don't have any questions, just welcome. Thank you.
Thank you.
Thanks.
Okay. Well, thank you both for coming tonight.
Thank you.
We tried to get you at the front, so we didn't keep you all night here.
Oh, thank you.
Okay, you can have a seat in the audience. I think there's room for you there. Okay, moving on to the annual reappointment of special health agents. We have Ron Beauregard for tobacco control, Denise Graffio, town clerk, for burial permits, Pamela Thomas as Tewksbury Animal Inspector / agent, Christine Gualtieri, Tewksbury Animal Inspector, Ashley Schimel, Tewksbury Animal Inspector, Casey Smith, Tewksbury Animal Inspector, and Maria Ruggiero, Special Agent. Maria Ruggiero is with the Police Department, and Casey is on the Billerica Police Force, along with Ashley and Christine as our 3 animal control officers. So for Tewksbury residents, we no longer have our own animal control officers. We have an arrangement that has been in place for at least several years now that Billerica and Tewksbury share them, but they're on the part of the Billerica Police Department. Okay. So would someone like to make a motion for the annual reappointment of those special health agents?
I will make a motion. I just have one question. You did not mention Michelle Grant. Do we need to reappoint Shannon Gillis as well, even though we just appointed her with the new name?
No, because we covered that in the first part, but yeah, we need to add
Okay.
Michelle.
I'm just looking at the agenda here. Okay, well, then I will make a motion to reappoint Michelle Grant, Ron Beauregard, Denise Graffio, Pamela Thomas, Christine Gualtieri, Ashley Schmiel, Casey Smith, and Maria Ruggiero.
Okay, so I'd like to second the motion.
Second the motion.
Okay, so Maria has put forth the motion to approve the annual reappointment of our special health agents. Mr. Scarano has seconded the motion, so we'll take a roll call vote. Mr. Rue?
Yay.
Mr. Scarano?
Yay.
Ms. Cirulis?
Yay.
Dr. Bichetti?
Yay.
Chair votes aye as well, so the motion carries unanimously, 5-0. So you can inform them of the good news tomorrow morning. Unless they need to be called tonight so they don't lose sleep. Moving on, under new business, we have local food code regulations. And we also have frozen dessert regulations. And for both of these, it's just more of a formality that we're taking state regulations that the department is supposed to enforce through state law and just including them as local regulations that allows us to add some local tweaks to the state regs. So we've been working on the food code regulations for a bit. And I think there were a couple of fine tunings that the department was looking at. So where do we stand on that?
So for section, under the permits, 5.4, all food establishment permits shall be renewed by December 1st of the year. It was issued. So we need to add a clause for if it's not in the office by December 1st, all the paperwork that we need, then the fee is doubled if it's not renewed in time.
Okay. Yeah, that was a question we had today because I couldn't remember if it was on the fee schedule, but I just wanted to put it in the regulation of what we have been doing to ensure that people get things in timely.
And then also a part of that, we're including seasonal as well, correct?
Yep.
Okay.
I'm sorry, I didn't hear that.
Seasonal.
Oh,
So
seasonal.
everyone, because for everyone, the permit expires. And if I remember correctly, the permit expiration date is set actually in the federal food code. So it's not something that we have
Yeah.
the ability to change. It's the federal reg. that
Yeah,
we
so
follow.
all permits expire December 31st, but per the food code, that everything has to be renewed 30 days prior.
Right, as we talked before, it's good just to have everyone do it all at the same time so that everyone's focus is on let's get them all done, and I think that helps everyone all along. And I know we included other things. I think, Dr. Shetty, you had mentioned a April 1st implementation date. So that's what we're going to have for
Correct.
an effective date on it. So once we get the department's final edits, we'll send them out to the board, and then we can vote to approve that at our February meeting. And then I've also submitted a draft of the regulation for frozen desserts, both to Mr. Scarano and to Director Gillis, for them to look at. Mrs. Scarano and I had a conversation because one of the questions at hand was as it relates to soft serve machines. While the state regulation has them being tested for bacteria levels on a monthly basis, the assumption there is that the machine is in use throughout the year or for continuous periods of time. And the question becomes when either a new machine comes online or if it's a seasonal operation that restarts business when the weather warms up and there are actually people willing to have ice cream, what type of upfront bacteria testing would be like to have in the rig. And so, Mr. Scarano, I'll let you fill in us on that because you were going to be talking to a consultant on that.
We did talk about implementing some direction from manufacturers of the machines as to sanitization, cleaning, maintenance, which we would like to incorporate some pieces into our local regulation. As it relates to the seasonal, we think it's important that the seasonal operators bring on a qualified testing laboratory early enough so that the testing can be done. We were talking about doing a soft opening in order to have that testing completed before they start serving the public, which I think we'll be able to reduce to a fairly simplistic formula for seasonal openings, which could also be used for hot openings on any ice cream vendor.
Okay, perfect. Well, thank you for doing that research. So I look for us being able to include that. This reg is going to be much shorter because we're simply taking parts of 105 CMR 500 that pertain to this and including that as local regulations and adding in the fact that we want to make sure that as per our local permits, that the permits are renewed on March 1st of the year. We can't, and stuff, because you can't say the end of February, because with leap year, then it's always going to be a moving date for what date things actually are good for. So we have a March 1st date on that. And everything else, we were just relying on the state regs. The only thing else we're going to add is just the initial testing. So if you want to put your thoughts on how that would be structured and get it off to me and Shannon, then we can pass it around to everyone else.
I will endeavor to put that together, and I think the only other thing that needs to be included here is when a laboratory comes back with an unsatisfactory result, that there be some self-policing mechanism and suspension of operations until the machine comes back online with a test and with a lab result that's satisfactory. That's the one other area that obviously escapes most folks. It does take a little time to get these lab results back, depending on what laboratory you operate with or choose. And I think it's imperative that once you have a good lab on your mix, that it occur on a interval that makes the public safe, and that there is some reporting. We can't always depend on the lab to send us the results. We're not CC'd immediately, but that's something that we really need to look at. Where there's a unsatisfactory lab result, it should come directly to us so that we don't have to rely on the self-policing as heavily as we need.
Yeah, because I know that from the state regulation that they specify the lab is to submit copies of the test results to the department within 3 days. But you're right, if it's a failing test, then
It should
we'd
be
want to be
immediate.
notified
3 days. 3
immediately.
days is too long.
Especially in this day, we can email or pick up the phone. And the other thing I'd added into this too was the fact that where there is an expectation that the department will be receiving these bacteria test results on a monthly basis, that it will put the onus on the permit holder to notify the department within X number of days of when the machine comes offline, so the department's no longer expecting to get test reports of that. So not having to proactively call the vendor to find out where's the test result, only to find out that the machine has been taken offline, whether for seasonal reasons or for other purposes.
And that's the other thing, is that if a machine is taken offline, many manufacturers will replace a machine with another machine. And that's something I think we have to think about going through this entire soft opening again, so that they have a period of time to start their mix, get a reading, and bring the new replacement machine back online if it's not the same machine. And if there's a bad reading, really, it's all about why was there a bad reading? Was it based on cleaning, maintenance, new parts, old parts not replaced? These are the things that tend to escape scrutiny on these ice cream machines, because The maintenance is replacing O-rings, bushings, using the correct types of greases that are food grade. These are the types of things that really have to be written in a protocol so that the operator understands not only that they have a bad reading, but why they got a bad reading, investigate that to try to mitigate anything happening in the future.
So let me, I guess, two parts in this. While that may sound onerous to a lot of people, the reality is, and correct me if I'm mistaken, that if someone is properly paying attention to the daily operations and maintenance of the equipment, this is not a lot of extra work you're talking about. It's just things break in the course of business, and you just need to make sure things are working at peak efficiency and cleanliness.
This is routine. This is what you do as a soft serve operator, a machine operator. The mix does not stay in the machine for extended periods of time. The machine gets cleaned on an interval basis. The machine gets serviced on an interval basis. The servicing is generally taken by the operator who disassembles the machine, spreads it out on a table, inspects all the parts, replaces what's necessary for gaskets and O-rings. That means that you have to have them in place. You have to have an inventory so that you can keep these things operating at peak efficiency, which keeps your bacteria levels down and allows you to serve a safe product all the time. So it's routine, and all operators should be working with their manufacturers and suppliers of both mixes and parts, accessories, et cetera, in order to make sure that these things are being assembled properly, and that if someone new is doing it, there's at least oversight so that no steps are obviated, posing a risk to the public.
Well, it sounds like, from my layman's perspective, and where you've been in business yourself, that even having a simple checklist would help. And I'm sure that manufacturers probably have those checklists, if not the companies that install the actual equipment, that they could provide to the user.
People tend to do the minimum. I don't think that's a shock to anyone.
No.
But in this case, the minimum isn't enough. You need to be doing routine. You need to have parts, accessories, additional O-rings, additional gaskets, additional greases, so that the machine goes back together. And hopefully, when it goes back together, you're looking at the mix, you're checking the mix, you know that you're having 30-day intervals for lab testing. Nothing stops you from calling in an interval lab test if you feel that the occasion has arisen that you would like to add a separate layer of protection. We're talking about adding food safe service to oversight in our food safety program. It wouldn't hurt to have the assembler be food safe certified as well, or have someone on site that was food safe certified, so that we don't have, let's call it occasional help or part-time help, trying to pick up the slack and get a machine back in service without going through the proper protocol.
So I know in some things, like some of the, not grease tanks, but the Big Dippers and so on, Mr., that we would, when someone come before us, that we wanted to make sure that they have an operations and maintenance manual, so that it was not left to someone's recollection that may or may not be there anymore, but there was something that people could refer to. Sounds like a checklist and an O&M manual, things that should be provided with this equipment anyways.
The O&M will be there. It's the experience. It's the experience and the routine of breakdown, proper sanitation, proper cleaning, proper assembly, and putting it back into service at the right temperatures. You know that these have cylinders in them that freeze milk mix that turns it into soft serve. So temperatures are, again, critical. Mix being held at the proper temperature is critical. There's a refrigeration component. It's not for beginners to be doing this without the proper training. That's why I think we're looking at our manufacturers to comment on our, Section 500 here.
Yeah.
To help and assist anybody that is putting these machines back into service. And of course, big machines are one thing, but they also have countertop machines, smaller machines that are now coming online for serving soft serve almost like on a daily supply rather than a 2-day supply with a machine. So you have limited service and greater service. All of these things, are not easy for oversight for our board and our inspectors. We have to depend on the operator to a large degree to bring the machine to a level of operation that's safe for the public.
May I add to that, Mr. Scarano? Because I totally agree with you. I believe that as a board, I think an incident happened last year or the year before, I can't remember, where someone that had been in business for 31 years, so they knew how to do everything, and there was some issues that arose from that. As Mr. Scarano said, it's very important that if people are going to be in business and they say they know the business, then they should know exactly what their responsibility is to protect the public. I can attest that these machines are difficult to clean and maintain, so it is not for the novice. And yet people have to self-monitor their equipment because we had an incident, as I said already, and someone said they were doing this for 31 years, and yet when our Board of Health agent evaluated the facility, it was clearly evident that for someone that said they knew what they were doing for 31 years, they clearly did not because of proof as the agent went in. So I think it's really, we want to trust people to do the right thing to protect the public, but they also have to take it upon themselves to self-monitor. As Mr. Scarano said, we don't have the manpower to go in and check to make sure they clean it, but we do have the ability to enforce the safety of the public. And at this stage of the game, and I think I've stated before my personal opinion, if you're going to be in a business and you're going to be impacting the public and put them at risk for health issues, then we don't want to have anyone put in a situation where they're providing a service, they're not doing what they need to do, and someone that has a novice, as Mr. Scarano said, that's just not going to work. So it's mostly to reinforce what Mr. Scarano said, that they can get all the assistance and aid how to do it, but they have to be self-monitoring, and we just have to trust by checking and verifying that they're doing it. If not, then we'll take it to the next level that I think we're aware of. So I just wanted to add that because Mr. Scarano was so correct with that. Thank you.
As a follow-up to Dr. Bichetti's comments, I think the across-the-board Serve Safe certificate and certifications, where you learn a tremendous amount about bacteria and how it is the enemy of food service, will go a long way in bringing people from complacency to a good execution, because that training really reinforces what can happen in a very short period of time.
Well, to dovetail onto that, that's why we're really hopeful that with Vincent Gu now on, that we'll have someone that's not only doing the inspections that can see firsthand what's being done correctly and what's not in our community, our member communities, but that he'll also be able to do the Serve Safe training as well, so that we get everyone all on a standard knowledge base. So I think that's going to help as well. Yes, Mr. Rue?
Mr. Chairman, point of clarification. This 30-day lab test that we talked about, didn't we already discuss this about that test being CC'd to the Board of Health? Didn't we already have a
Yes, we
discussion?
did, Mr. Rue.
Okay, I thought
Yes.
we were going to get the results of those 30-day tests.
We do get them monthly
Okay, so we
when
do
they're
get them.
done. Yep.
Okay.
And they're always reviewed by our department. If there's an issue, we
Okay.
follow up with the
Okay,
establishment.
okay, thanks. Thank you.
Yeah, it was more that when there's not to be a test coming in,
Right.
we want them notified, so they're not spending time trying to figure out why.
Right. But as a result of those 30-day tests, would they indicate that there was an incident that occurred within, okay, so would be notified that something had occurred, and if something needed to be done to go back to the owner of the facility, we could go back at that point. Okay, good, thank you.
And it's not a pass-fail test. Actually get a reading account.
Yep.
So you know from the count where you stand with the operation of your machine. So this isn't a pass-fail thing. You have a count, you have a bacteria count, you know what an acceptable range is on the test, but you also see the reading, and that tells you where you are at in your maintenance cycle. So you may have got a test where you may have got it in 3 days. It may very well say, there's an O-ring, there's an issue, because you're getting a higher reading. And those things an operator should be keeping those readings, looking at his maintenance schedule, determining, when he did last change parts, and et cetera, et cetera. This is the science behind making this work. So like I said, it's not a pass-fail thing.
And I think it's important to note, too, that these tests, they're not just the test whether there is the presence of bacteria, but there is an allowable limit for bacteria.
Right.
Bacteria is a normal part of the process, but they're trying to make sure that there's not an excessive level.
Correct. There's bacteria in the process, and we're making sure that they're within tolerances, but those tolerances are high, low, and this is the type of information you take, process with your whole group, because there may be somebody introducing mix into the machine, and it could have started with the wrong temperature in the cooler holding the mix. It may not be the machine. This is why you're looking at that operation from a standpoint of delivery from the vendor, storage in a cooler, brought to the machine area, introduced into the machine. These are all points where there may be a problem, but the more routine you have and the closer you can stick to a routine by having, limited people doing this, the better off you're going to be. And the more likely you're going to have a mix that is being processed and produced that is the safest thing that we can do.
Okay? Well, thank you.
And again, as a segue to Mr. Scarano, that's why it is imperative that Serve Safe training, and as I said in the past, I did take the Serve Safe training. I guess if I wanted to open a restaurant, I'm qualified to do it. There's a lot of knowledge there that's imperative for anyone in the food service business to be aware of, and that will help them troubleshoot the potential weak links where a situation may arise. As Mr. Scarano said, it may not be the machine is not working properly. It may be another step along the way that there was an issue with. So that's why it's mandatory that someone has to have experience and they have to be ServSafe certified to be assembling and dismantling this equipment according to the routine cleaning protocols that have been established. And there's just too great a risk for people to have health issues if it's not followed basically within that appropriate standard deviation that's listed. So just again, anyone that is going to be in this business, they really should be making sure that someone of experience with assembling the machinery, as well as knowing all the critical points where there could be problems, need to be well qualified. And I think it's mandatory that someone serve safe certified. We do have Vincent, and welcome on board again, Vincent, and the rest of the people that were appointed today. But you need to have those checks and balances in place, because this is one area where we can control the safety of products. And business owners, they have to self-monitor. They may not like it. It's inconvenient. As Mr. Scarano said, people will always do the minimum. And this is one case where the minimum isn't even enough. There's just too many critical points that can be affected. So thank you again for that spoken description of what needs to be done with the machinery, Mr. Scarano. I know you're very familiar with it. So thank you, Attorney Scarano. Appreciate it.
Okay. Before we move on, just any last comments from you, Mr. Rue or Mr. Rulis?
I'm clear.
Okay.
No comments, thank you.
Okay. So moving on to old business. Oliveira Farm update. So,
I had written a letter last week that was sent out to the Oliveira Farm, as they still have some animals on the property. And those are to be removed by Tuesday of next week. I spoke with the animal control officers this afternoon, who went out to the property today with the state inspector. At the property currently, there's 1 horse, 1 pony, 2 goats, 5 chickens, and 1 rooster. Eileen is back on the property and taking care of the animals. So the horses have gained some weight and they seem in good health, and everything at the farm for the animals seem okay. But at this time, as we know, they don't have a permit to keep any animals. So the animal control officers are going back on the 26th of next week to make sure that the animals have been removed from the property. If not, then that's when we're going to back fine from the date of September 21st, when our original order letter went out.
okay, and you'd also been in touch with town council today, and he has not heard from the Oliveira's lawyer, because at this point, it's lawyer-to-lawyer communication.
Right.
And these animals are pets, not slaughter animals, correct?
I believe the horse, pony, and goats are, but I believe it's my understanding that the chickens and the 1 rooster that are left, they couldn't corral
Yeah.
the day they removed the other animals.
They're tough to get in the daytime.
Is there anything that prevents them from having to go through the process of getting a permit for the keeping of fowl pending their removal? The only issue I raise is that the rooster isn't allowed. The chickens would be allowed with a permit, even though there's not a keeping of animals permit available to them at this point.
As with the horse and the pony, correct? They've got the acreage there to have the pets. That's why you
So,
have the pets.
but they have the ability, and I think town council could mention that there is a process that would bring them in compliance, absent taking them right off under our order. So, and I only mention this because we were queried by the Oliveiras during the process of hearing on the revocation. They had asked the questions, how could they be in compliance? So we should not be remiss in providing them with the opportunity of compliance. Even though our order currently stands, they have not taken advantage of a route to compliance. And I would only indicate that maybe we should respond to town council that we do have a route to compliance. They asked about it, and I'm wondering why they haven't taken advantage of that.
Mr. Chairman?
Yes.
I believe
May
before
may I
the
ask a
problem
question?
was
Hasn't that route
the-
to compliance been available for more than a year?
I can't answer the timeline. I can answer the fact that during the revocation process, we were asked about the road to compliance. And we had indicated that there were alternatives. They have been in non-compliance for
4 months.
4 months. And
Okay, well, if recollection serves me well, at the meeting when I believe you were having dialogue, Attorney Scarano, with their attorney, and questions had come up at that time, I believe their attorney had stated that they already have all their appropriate policies, procedures, and remedies available. So, this just seems like it's been an ongoing thing. We've discussed it. I'm just a little concerned that, they've supposedly been aware of this. These remedies should have been corrected and the issues. So, compliance, I was under the understanding that when you spoke with that attorney that day, I can't remember the date of the meeting, but I'm sure our BOH notes reflect it, that they said they already had it under control. So it's clearly evident they didn't have it at that time. It's clearly evident that they don't have it now. And I think that, it would be good to check with town council to see where we are and maybe review the notes, because how many times do you have to tell somebody something that they say they already know? And I think we've given them the benefit of the doubt much longer than I know personally I would have preferred to.
I agree with you that we have given them every opportunity to come into compliance with their slaughter, with their keeping of animals. But at this point, what we have is an uncontrolled situation with chickens that we know that we can control, and it's in both the town, neighbors, and the board's best interests to have some oversight. We have the resources available to have is it Pam that goes out and does the pre-inspection? Pam could go out and do the pre-inspection and bring these chickens into compliance for everyone's safety, including the Oliveiras, and have the rooster removed. And whether they keep the chickens or not, it's incumbent upon us to make sure that they're healthy and that our regulations are being followed as to their keeping. We have a protocol for this.
So for chickens, that's a
Absolutely.
registration. So that's a different process than keeping of animals. However, it's the property owner. That's where the issue lies with this property, where the owner of the property has some health issues going on. So it's my understanding it would fall under the power of attorney to take responsibility to apply for these permits and registrations.
And that's what their attorney is there for.
And it's from my speakings with her, she has no interest in having animals at the property. It is these horses and ponies and goat that are considered pets for the daughter of the property.
At your authorization, can I say something?
Yeah, go ahead.
Mr. Chairman. So there's a difference to me between the slaughter animals and the processing of slaughter animals and the pets. The problem before, as I recall, was the neglect of the pets because Eileen was not allowed on the property. Eileen is now back on the property, and the horses, did you say, were back in good health? There are no sores and they're at weight and whatnot. I think we need to understand that pets are different than the slaughter animals. And if there's some remedy there for Eileen to keep, the chickens in a coop or something, if they're not slaughter chickens, I don't know what they are. They probably are. And the goat and the and the horse and the pony, then I think we should offer her that. I mean, they're pets. They're not.
But they would need a permit, so they have to apply.
Well, they had one, didn't they, at some point?
Yeah, it's revoked now. So they
So
have to
they
go through
don't have a permit right now, but
Right.
there would be a remedy in that if they were to apply for a permit, they have the acreage there, and they have the open area there, and she's now allowed back on the property, so the animals are being taken care of. I don't know if that's an option, or do we want to
Well,
even tolerate it at this point, based on, I mean, I can feel Tony's vibrations over the phone.
So one option that I'd offered at several occasions when we were having meetings in person with them in this was that because we were looking at having the animals removed right now, did not preclude them from ever coming back before us to request a permit for the keeping of animals. But our concern is twofold. One, most likely the chickens that are there are slaughter chain because the chickens are free ranging. So there was no way to distinguish which was there for egg production, which was there for slaughter chain. The bigger thing is the fact that being in non-compliance with the Board of Health regulation. And the easiest way to take care of that was to follow the original order that we had, Department put in them, of to remove all the animals. Just like any other property in town, if we find that there are animals there that don't have a permit, our first response is, oh, we'll forget about that. We'll ignore that transgression. We'll help you get a permit or registration for them. No, we want to make sure that they meet the letter of the order. And once they have done that, then if they want to apply for a new permit or registration, so we're not preventing from doing it in the future. We just want to know that they completely rectify the situation first.
Right, okay.
But we have a correspondence out there that says remove, doesn't give a second option of compliance. So how do we pass that message along? Do we modify, do we talk to town council about modifying the correspondence and adding any reasonable, let's call it, solutions pending the removal of these animals? But it's our goal as a board to make sure that if there are animals there, that they're kept properly. The chickens especially. We have a protocol. We have a absolute permit process. I don't know what the chickens are or whether they're slaughter or they're laying eggs for the family or not, but I think that due process requires that they know what their options are, and I think we should talk to town council about making sure that they're clear on their options, so there's no confusion going forward, period. These are your options.
I think that the sticking point has been that it's an internal family matter about how the power of attorney has a differing opinion of use of that land and not
Eileen
wanting
doesn't own the
things.
May I interrupt for a second, Chairman?
Go right ahead.
My personal opinion is I'm very reasonable, and I think for our fellow townspeople, the Board of Health has always tried to make rulings that are rational and reasonable and what's in the best interest of the people and public safety. But I have to tell you, we have wasted so much time on this particular issue since its inception, and I believe there were issues going on before it became public to us and to the rest of the community, that my patience has worn thin, and I agree with Attorney Scarano that the people should be made aware of their options, whatever they are. I think we always try and be fair and reasonable, but I feel that our goodwill as a board, an elected board, has been taxed beyond what I would consider reasonable. And, you know, I'm hearing a power of attorney on this. I don't believe that that's our issue. I believe that we as a Board of Health, I feel like we're getting involved in a family matter. And from what I have observed has occurred between our board and the newspapers and the infighting and whatever you want to call it, I just think that I'm in agreement with Attorney Scarano. We want to do what's best for public health, the animals, make an accurate definition of what type of animals they are. But I kind of feel that we have been intentionally stressed for a level of goodwill and taken advantage of a board, and it has caused an inordinate amount of time to be wasted on a situation that it seems like it's Groundhog Day and it's never ending. So I would hope that the rest of the board members would reflect upon this, because it's taking a lot more time than it needs to be. And I think we all feel we want to do what's best for public safety, the animals, and all parties involved. But I feel like we've been taken advantage of as a board, and I, for one, am tired of it.
Well, technically, anyone can submit a permit for the keeping of animals or registration for keeping of a small number of chickens or rabbits, but the first requirement is that the applicant for the permit or registration has to be the property owner. And that's where this all
makes
falls
sense
to
to me.
pieces.
Sense to
Because
me.
the person who is claiming ownership of the animals is not the property owner. And the property owner is medically incapacitated and has his sister as power of attorney. And because it's through a lawyer on their side, it's our town council conferring with the lawyer that's representing the family. And our
I'm well
biggest
aware of
challenge
that,
is
Chairman. Well aware of that.
no communication back from that side. The only time we were communicating with them was when we were having them come before us at monthly meetings. Since the
Well,
permit
no
was,
communication in my world means I believe in this case, maybe in other situations, but I believe in this case it's been intentional. I think it's been delaying. And I think that we as a board, and we have to talk with the attorney, do what's in the best interest of public safety and best interest of our community and the animals. I don't want to be splitting hairs. And like I said, you only reiterated everything I was well aware of. But at this stage of the game, if they're not getting back to us, then the onus is on them. And I think we have to act as a board. So Attorney Scarano has made those recommendations. I think we ought to talk to town council, give them their options. And then if not, if we don't hear back, I personally am tired of us reaching forward, trying to do what's best for public safety, the community, and the individual parties involved, and no one gets back to you. So therefore, the status quo will continue, and the status quo is not in the best interest of public safety nor the animals. And, I think we've spent a lot of time on the chicken rules. I think we came up with something fair. But this seems like it's just, they're abusing the goodwill that we've had. So I'm leaving that out there. That's my opinion, but I'm just tired of Groundhog Day and spinning wheels.
I can honestly say that, this process has evolved. It has not been static, okay? There were different factions of a family struggling for control while we were unfortunately placed in a position of making decisions in the public's health. My understanding is that the family situation has been stabilized, that the actors have changed. It's difficult for us to group them all together and say, you've wasted our time collectively. That may very well be true, and Dr. Bichetti very observant in picking that up. But just recently, One of the family who was actually prohibited from going onto the property has now been allowed back on the property. The health of the animals has changed. Some of the things that we were looking at in the past no longer exist. There's a power of attorney. The power of attorney allows that person to stand in the shoes of the owner, can allow anyone under that power to ask for a permit to rectify this situation, and we could continue on dual tracks to either remove those animals because there's no permit, as Mrs. Gillis has indicated in her letter, or we can seek from town council that they are aware of the options to bring them into compliance while this is going on, so that we don't offend due process and their rights. That's all I'm saying. There's no need to rush to judgment. Town council should make an informed decision on how we should proceed. We're not here to make that decision. We're here to take the information, consider it, apply it to the facts, and make a decision. I don't believe we have all the information necessary to do that. And that's the reason I said...
I agree with you, Attorney Scarano. I agree with you, and I just think that we need to address town council and get the information so we do what's in the best interest of the community, public health, and the animals. If, options are good. But I think we need to make options, because even though things have been changing, no one's communicating with us. So what are we to think when we reach out? Agent Gillis reaches out and she doesn't get a response back. Or we reach out and we don't get a response back. That's, I think, the frustrating point, the way I perceive things. So, and maybe town council can get a response back from whoever their power of attorney agent is.
See, I disagree with divergent ways of approaching this, because it's very simple. They're aware that a property owner has to apply for the permit, and the property owner right now is the power of attorney, and she has expressed through her lawyer that she has no interest in having animals at the property. So as long as she has that opinion, there is no permit application coming from them.
That's the point that we were going to make before, was Eileen owns the pets. I'm very happy to hear that the pets are back in good health, thanks to her being allowed back on the property. But if there's no contractual agreement between Eileen and the power of attorney, the animals can't stay. They have no place to stay. So,
Makes
but
sense
that's a
to me,
legal matter.
Mr. Rue. Yeah.
That's right, that's a legal matter. That's why we asked town council to address it and address us. And, at that point, we have a decision to make, but at least we're fully informed on what decision we should make. So, in all due respect, I understand there's a letter out there. There's a letter that's looking to impose fines and looking to impose sanctions. And I don't disagree that those are in order based on Dr. Bichetti's frustration and the board's frustration. I think he laid it out well. We've given them every opportunity. But if we fall short of the one opportunity that we have to have them straighten it out with town council, with their council, if they write back and say, we have no intention of filing a permit, we know exactly what to do.
Because what's happening is the attorney's focusing on the business and the animals associated with the business, and these pets were left over here on the side, and that's not what the attorney was hired to do. That's not what Dennis's sister hired him to do. And now you've got Eileen with limited resources on the property, but.
And any action we take isn't going to be against Eileen.
Right.
Any action we take is going to be against the owner.
Right.
And it seems like there's a breakdown in communications right now. We have a letter out there. This isn't something, the animals are being cared for better than they were before. And at least this situation is stable. It would seem to me it's not a far stretch to have town council reach out and see if he can come to some final resolution so that we can make an informed decision and not put the town or the board at risk for making it.
If I may, so the original letter that went out to have the permit revoked, when the attorneys spoke with each other, they were well aware of what our intention was to have the permit revoked. So at that time, the power attorney was in agreement to have that revoked and had no intent of having animals. So she's well aware of the process if she wants to apply for a permit. It's been 4 months and we haven't had a permit application and the animals have not been removed from the property. So that triggered the next letter that I just sent last week. Since it's just gone on way too long, they're hoping that we just go away. So unless there's a penalty, they're just going to try to keep on having these animals at the property unless there's a next step. And I believe this is the next step.
I agree with your conclusion. It's the facts that escape. Because there's been a change of circumstances as recently as November. There's been a complete change of circumstances.
But the burden of proof is on them to prove it
There's
to
no
us.
doubt, there's no doubt about it, but the parties have changed.
Well, not the key party, not the power of attorney.
No, but the people who occupy the premises have changed. And we have a person that has animals there, and we need to determine whether or not there's some agreement. It doesn't have to be an agreement in writing. It's simply an acknowledgement. Acquiescence is enough to create this relationship. We need to clarify it. We need to terminate it, end it, and send it in one direction or another. I'd love to go along with the letter and say, we're going to fine you. But let's explain the fact that they have an ability to come into compliance. I don't know what the changed circumstances are. I don't even know if the lawyer's aware of what's happened and transpired. All I know, as late as November, one party was out, the party that seemed to be causing us quite a bit of frustration. There's a new party in there that has ownership of animals on a property that we have no idea whether or not there's been acquiescence or implied permission or anything else between them. Let's find out. It's that simple. And then we don't put anyone at risk, them, us, or the town, for doing something that we could have thought out very easily, had town council issue an opinion, and we can rely on that opinion and move forward.
So let me ask you this then. So a simplistic way of looking at this is we could put a request to town attorney Kevin Feely or town council Kevin Feely to, or with you, write a letter to the Oliveiras,
Clarify the
asking them
relationship.
to state their intention of, will the power of attorney, do they want to have animals kept on the property? The problem is that we may get an answer, if we ever get an answer, but then if the answer is no, everything keeps going. There's nothing that we have except for the fines to draw a line in the sand. Because
The letter should stimulate some action on their end, for sure. They want
You want
to
to find,
keep animals there.
you want to find the owner for someone else keeping animals on their property. Because that's what's happening right now. If we go along with the thought process that we're currently involved in enforcement, the owner, the one that's disabled and is under a power of attorney, is the one that will be fined. We have this other relationship with the power of attorney and a new party on there with animals. It would seem that if there's no agreement to keep the animals there, we know what direction to go in.
Well, put it this way, we have not
Correct.
been, Department's not been informed officially that there has been a change in the wishes of the power of attorney in terms of allowing animals on. So that's why the department's been proceeding on the course they have been, because there has been no formal communication otherwise.
Since
They
the
have no
change,
permit.
since the change in circumstances.
But they have no permit.
And the permit was issued to the property owner.
Right.
So
Right.
these animals that are
They're part of the bigger.
Eileen's have always been Dennis's permit. Never Eileen's permit,
Right.
it's Dennis's.
I mean, no what matter happens to the property. The
Right.
property owner is the one that's ultimately responsible for what happens on the property and how it's used.
Yep.
And if that property owner, through the power of attorney, is saying, I don't want this use anymore,
Great.
and that's what, and the only thing that has not happened is that we have not, the department has not received a letter with that simple statement.
Correct.
So that's at most we can ask for, but then it's, we need to put a deadline and know that there is a remedy that we can levy if they fail to comply in answering that.
I don't think our remedy is going to change. Mrs. Gillis laid out the remedy quite succinctly.
Right, and $100 a day, it's over $12,000 in fines right now.
And that's correct. So let it sink in on what needs to be done. We need a response. We need a response because the parties have changed, the circumstances have changed. The only thing that hasn't changed is the fact that we are still stuck with enforcement. And now the person that was causing a problem is gone. There's a new person here that appears to be somewhat more agreeable to terms. And if there's a clarification of the relationship between those two people, it's either A or B. It's no, and the enforcement takes place, or it's yes, and they got to come into compliance. It's not going to change what we do. It's not. But it will grant them all the due process that they're entitled to before we act. And that's the only thing that we can do as a board, is
So
to
we're
make
gonna-
sure that we were fair
I agree.
in the process.
So we're gonna
I
send
agree
a
with you,
letter-
Attorney Scarano, and I think that that's the prudent thing to do. But so this situation will be going on ad infinitum if we don't get a response. I mean, you're an attorney. I'm a doctor. We contact people. We have a situation. We expect to have the attorney get back to them. Is the problem we are having is the person who has the power of attorney and their attorney is not answering, or is it the person that owns the property is telling their attorney to not respond? I think that's what's frustrating. I want to give people the due diligence that they need and the due process, but is this, I mean, do we have any inkling from town council why no one's getting back to Agent Gillis? Do we have any idea why no one's responding? Like like Shannon had said, it's like the situation isn't going to go away. So we just need people to work together and somehow mitigate this in a reasonable fashion for all parties.
That
So,
attorney's purview, Tony, I believe, was the business. I bet you 10 to 1 it did not include the pets whatsoever. And now there are animals there which are pets. They're not the slaughter animals. They have nothing to do with the business. I bet you that's the problem, but that's not our problem. That's their problem.
Well, the attorney
It's
informed us
correct.
that
And
he's
weren't these
acting on
animals
behalf
thought
of
to
the
be
family.
slaughter animals first before they were pets, the way they were purchased? And correct me if I'm wrong, I thought that these animals, the only animals on the property were animals for slaughter, and they had different licensing requirements. And for some reason, they were no longer considered, or they didn't have the appropriate documentation to allow them to be pets. Of course, I would love to see pets be well taken care of, and I'm glad to hear as a board member that these animals are in better shape than they were before. But it's like, I mean, the way it sounds, it's like we got animals on the property, but, you know, the landowner does not want to, or the power of attorney does not want to go for the permit, but yet they're letting the person on. I mean, I thought that would have been considered trespassing if someone's on someone's property without being allowed to be there. So I can't see how you can have one without the other, and all it appears to be doing at this point is delaying, as Shannon had said to us.
The keeping of animals permit was for keeping of slaughter animals.
Correct. And weren't these animals initially brought on board, and when we found out that we initially thought they were slaughter animals, and then we found out they were on the property and they didn't have the correct documentation, so they neither slaughter animal or pets. There were kind of some in between.
So our permit doesn't specify between slaughter animals or regular animals that are just kept on as pets, but the horse and pony have always been on the property. So I don't believe they were ever
Okay.
intended for slaughter. As far as the
Okay,
two
thank you,
goats,
Shannon. Thank
I
you.
can't speak for, I don't know well enough, but I would imagine the chicken and roosters were intent for sale.
Yeah, and I don't think those other animals
Okay.
were ever listed on any of the keeping of animals permits back from, was it 2014 that we had with Director Clements?
I think it was older than that.
It goes back a while.
You know that the fine that we're about to levy is appealable.
Yeah.
There will be an entire, if it is appealed, there will be an entire hearing, a factual evidentiary hearing on this. Our job as a board is to make findings of fact to prevent that from going astray in Superior Court. It would be easily remanded back to us to make findings of fact so that the judge could either review them, adopt them, or find differently. We need to complete the process as a board. What I think that takes is having town council contact their lawyer, find out what the relationship is, what the agreement is regarding these animals, send it back to us so that we can make the proper findings of fact and adopt the, let's call it, penalty that Shannon has indicated will be assessed. It is a simple process. We're not in a hurry. We just want to be thorough. So with that in mind, I'm going to put a motion on the table that we table the discussion until such time as Attorney Feely, Town Council, can contact either the power of attorney who's no longer represented by a lawyer, then she's pro se. He can contact her directly. If she's represented by counsel, he can contact her counsel. One way or the other, we'll find out what the understanding is between the power of attorney and the person who has the animals. Step 2, there'll be a recommendation. Come into compliance or remove the animals, or the penalty will be assessed. We'll make the proper findings of fact if it comes back to us or it's not resolved by town council. That's my motion. Table this until town council can investigate it, determine the relationships, and make a recommendation to us.
You okay with that, Tony? You want me to second it?
Well, there can be discussion on the motion.
You out there, Tony? I'll second the motion.
Yeah, I think it's probably cleanest that we do this motion because we've done the
Could you
motion
repeat
before.
that,
and had
please?
you
I couldn't
issue
hear
a
it.
letter.
The motion was to table discussion this evening, refer the matter to town council so that he can investigate the relationships between the power of attorney and the person who owns the animals, determine what course of action they're going to take, and report back to us so we can make the proper findings of fact and make a decision on whether or not we're going forward with enforcement.
I'd like to amend one part of
I'd be in
that.
Discussion.
I would be in agreement with that. That sounds like a reasonable, prudent approach, Attorney Scarano. My only concern is I think we need to put a time limit on this because I don't know what has taken so long to get a response. I understand the current climate of delays, but I'd just like to have our attorney, if he doesn't hear back with proper legal notification on this, I'm glad the animals are being better taken care of before, but I just don't want to see this go on for ad infinitum. As Shannon said, thinking it's going to go away because we need to make a proper ruling. We want to do what's in the best interest of everyone as best that can be achieved. But only thing I would add to it is let's put a time frame on it. It's middle of January now. Realistically, between now and the next meeting, I would say that we need to hear back definitively, yay or nay, before our next meeting, in an appropriate time to post notice for Shannon to post it. So that's my own. I'm totally in agreement with you. I totally understand what's going on. I don't like how it has transpired, but I'm okay with that. But I just don't want to hear from 6 months from now that we still haven't heard back from anyone, because I think it's totally disrespectful to the board. And life does go on in spite of illness, in spite of catastrophe, calamity. Life does go on, and we have to move forward because I just don't feel we need to spend much more time. But I think your solution is reasonable. I just would hope that the rest of the board members would consider a time frame where we can expect to hear back. And if we don't hear back, then, like I said, we don't want to penalize anybody unnecessarily, but not to respond is an answer, the way I look at it. So that's all. But I'm okay with what you had suggested, Bob.
What I'd like to
Why don't
propose
I-
is that the letter that director's already sent informing that they need to have the animals out by next Tuesday. Next Tuesday should be the deadline for getting an answer. And simply, we just need to have in writing from them their intent.
Then I'm okay with that, Ray. If we've already got a time frame,
Because
I'm
we've
okay
given
with
them
that.
plenty
Ray.
of time, and if we
Just-
give them
I can't-
another month, it's going to keep dragging out. They already have a January 22nd or
25th.
25th deadline on that
Yes.
letter. So I think it's well within reason that we hold them to that
So
same.
we
and
amend
just-
the motion to add that a response from the power of attorney should occur to town council by the 25th, which would give them time to have that discussion. I think it's a short period of time that you're working with. We have COVID and everything else going on. I understand that I understand that you
Is COVID through the
folks
phone
want
lines
to.
right now or through email? I'm unaware of that. That's, how much time does someone need, Attorney Scarano, to give a response of an issue that's been ongoing that I honestly believe they have to have been aware of?
Well, I guess the answer to your question, Dr. Bichetti, is a reasonable amount of time.
Billable hours.
A reasonable amount of time would be exactly what the court said. Did you grant them a reasonable amount of time? I don't know if
Well,
that.
I think a
time
week
period
is a reasonable
reasonable.
amount of time to make a phone call, even during a nuclear disaster, if the phones were working, yeah.
And I would want to make sure that what we're looking for them in writing by next Tuesday is a simple statement. Will I allow animals to be kept in this property or no?
Then the motion is to have Attorney Feely reach out and get that answer. There was a time.
Can we
There was a
also-
time.
Right.
I'm sorry.
No, that's okay. Can we also add that this is in normal Eastern Standard Time, not attorney time, because I know that attorney time sometimes is on a different format than reasonable time. I can only speak from personal experiences.
From personal experience,
I've dealt with
I think
attorneys.
a
I just want to make
doctor's
sure we're in
minute
the same
and a
format.
lawyer's minute
metric
are the
versus
same
English.
minute. Just to be clear, I think a doctor's minute and a lawyer's minute are about the same. They're
I thought it
both
was in
not a minute.
6-minute intervals, but yeah, I thought attorneys were 6-minute intervals, but that's.
So, if you think the 25th is a reasonable amount of time to get that answer, and I don't feel one way or the other on that, I think Attorney Feely should reach out. If he needs additional time, he'll notify us.
Yeah.
Okay?
But that's okay. I'm okay with that. I just, like I said, I personally, my opinion would be willing to. I was not exactly sure of the exact date that Shannon and Ray brought it to our attention, but I personally would be okay with, and what I would think would be reasonable between the 25th and if the town attorney, town council thinks that they need longer, I'm okay with that, but I would say I'm not okay with anything longer than prior to our next meeting. I think that's more than enough time to just ask a simple yes or no question for a situation that people have been aware of, regardless of the permutations this has taken. So we can maybe put it into a motion that it satisfies what we need to do in the best interest of the community and public health as a board, the best interest of the animals, and how we can resolve this and, as fairly and as considerately as possible based on the time that's gone on with the whole thing.
Well, I understand the frustration with the time that's going on. The time that's going on is really an irrelevant factor. What factor is important is that if town council reaches out and he needs additional time, he should report back to us that he needs additional time to resolve this so that we don't get involved in litigation over it. Because that's what we're trying
I'm
to
okay
avoid.
with that,
That
Bob.
memo
I'm
was
okay
sent
with
out
that.
on the 10th of January.
Yeah.
And
Was that sent
Kevin
certified?
Feely
return
was
receipt?
copied on it.
Yeah.
Hasn't been
So he's-
returned yet.
I mean,
But I
we
emailed
Where?
them.
There should be some stimulation on their end already.
Let's do the follow-up. We've got a motion, and I think
A
we've
target
amended,
date
we've
of next
amended the
Tuesday.
motion to include Kevin Feely and making a determination as council on whether or not he needs more time to resolve this issue in the interest of avoiding any further conflict. Because this could put this all to rest.
Peter Lawler was on that correspondence as well.
Yeah, he's their
And
attorney.
Kevin Feely was on that correspondence. That was sent out on the 10th. So I don't think it's, the target for next Tuesday is a unreasonable date.
Excessive?
And if
Yeah.
he needs more time, he can let us know.
Yeah.
Yeah.
You know how attorneys are, Tony, right? Of course they're going to need more time.
Which ones? The ones I like or the ones I don't like?
All of them.
Sounds like we're just
I'm
grouped
okay.
in with
Or
a
if you
bunch
find
of
more
chickens.
decay, that's going to take longer too.
What's that?
If you find more decay, that's going to take longer too.
That's usually what that usually requires a return trip.
Yep.
Take a look at those gums.
Well, I'm glad.
We-
Do I need to restate the motion?
Most people
Maybe.
would prefer to have the situation rectified ASAP. This
So-
is not one of them, I
so we're
guess.
going
But no,
to
I'm okay,
restate.
Bob. All kidding aside, I just want to do what's best for the town, public health, the animals. I'm very pleased to hear that they're taking back. I don't want to get involved in a family squabble. It's tough enough
Right.
for individuals to deal with their own situations, and I feel like the board has been stuck in a family squabble, and it's like, I understand they happen. I understand that they take a while to be resolved, but I also know that it shouldn't take this particular amount of time because, to my understanding, all the parties we are talking to now were in this situation when it started, and it's kind of mutated, and the mutations have not been for the best interest of the animals, public safety, the individuals involved, nor the Board of Health. So
So it
but
sounds like,
you do make a reasonable approach. Yeah,
It sounds-
I'm okay with that. If they need more time, fine, but I don't want to see more time go into 10 years
So
because
it's-
that's attorney time. I've seen that.
it sounds
And those
like.
are billable
It
hours.
sounds like Tony is seconding the motion with a target date for Tuesday, no?
I think we just simply need to restate
We're
it.
just going to restate the motion. We're going to table any further discussion. We're going to refer the matter to town council. We're going to have town council contact whoever is still represented in this case. He's going to make a determination whether or not these animals are allowed by the power of attorney. He's going to report back to us within the time limits that Shannon has on the notice and enforcement letter. And if he needs further time, he'll contact us and we'll bring it back up for hearing as soon as possible.
Someone willing to second that
second
motion
that.
without restating it?
Are you going to second that, Tony, or do you want me to?
I second that. That's about as fair as I believe it can be to all parties in this situation.
Okay, a yes
Board
is
of Health
fine.
included.
Yes. Yay.
Okay, motion's been
Yes.
put forth and seconded. For anyone decides to add more
I'm going
verbiage,
to say yay now. I may be in a bad area where the phone may drop, so let me
Okay.
give you my yay right now, please.
Yay.
If
Okay,
it
Mr.
doesn't
Rulis?
disconnect, that's fine. But
yay or nay?
Yay, yay.
Yay. Mr. Rue?
Mr. Rue,
Yay.
Mr. Scarano.
You'd like to add
Yay.
something?
No, no.
I was afraid you were going to abstain. Chair votes aye as well. Motion carries unanimously 5-0. Let's move on from this item to director reports.
Okay, so I pulled the numbers from the state system today. I usually pull them on Fridays. So today, the case reporting for Saturday to today were 227 cases, which is down about 300 cases since the start of the month. So we're trending downward in the right direction, hopefully. So that is good news.
And those are new cases.
Yes.
Okay, and I also pulled down the data from the state that they put on their website just after 5 o'clock today, albeit it's a week behind, but the graph that I've been plotting is showing, while the rates are still going up, it's greatly tailed off. So it's sort of the start of the, looks like the graph will show we hit the peak next week and we should be going down. So I'm more optimistic and go by more of the numbers that Shannon has in terms of the new case count. But now at least we have decreased for 2 back-to-back weeks. So I said last week, 1 week does not make a trend. 2 weeks now, while it's not a trend, it's definitely sloping in the right direction. So when we had our emergency meeting last Friday, I had stated at that point that we would have a meeting tomorrow at 11 if the numbers looked like they warranted having us to meet to see what action, if any other, we would need to recommend. And with the numbers as they are presented tonight, especially with the case count going down for the second week in a row, I do not see the need at this point in time to have to hold that meeting tomorrow. We will still look at if we ever need to have a meeting, because of how things are reported, it would be on a Friday, but there is no need to have one this Friday because things right now look like they're going in the correct direction. And we just reiterate that people keep following what was listed in the health advisory of just do the common sense things that we were all doing last year that brought the curve down, and not asking anything different, just do the right thing, practice common sense.
Raymond, I've got some MWRA numbers for you for the COVID missamplings.
Go right ahead.
Deer Island, 2 weeks ago, I reported a 41% drop in COVID samplings coming out of Deer Island. This Tuesday, it was between 65 and 75% drop in the COVID rates. So, and I know our sewerage goes out here, but that's a pretty big sampling of where this thing is going. And I just want to be, I want to send a message of hope out there to the public that that we need to look at this as a cup being half full now as opposed to half empty. We've been too negative on this, and I think things are looking good. And if a new variant comes up in September or October, right before the elections, I'm going to have a real problem with all these politically motivated statistics. So I just wanted to make that my final statement of the night.
Well, and as an engineer, I think
And Mr.
that's more important trend right now because the testing numbers are purely based on those that are getting a PCR test. And as the state and the federal government now providing the rapid test for home use,
Yep.
that means that, yes, on one hand, there'll be fewer PCR tests positives being reported because more people, I'm sure, are shifting to rapid test, and with the continued problems of trying to get a PCR test and standing outside in these cold days, it's sort of driven those folks to unofficial reporting, and there is no requirement that if someone tests positive on a rapid test, you tell anyone,
Right.
much less the state that tracks these numbers.
And may I add one thing that in full disclosure from the Board of Health and myself, not one of the members for the Board of Health were involved in the sampling of the decreasing numbers. They were all taken from the Mass Water Resource Association. So, and I believe they are scientifically based. Because a lot of people drink water from them. So
Yeah, the
I think
doctor's
that's
name-
an important
yeah,
thing.
the
So
doctor's-
that's full disclosure. So Mr. Rue, you had no
I
input
wasn't
in the
there.
sampling, correct?
Right. Dr. Paul Sachs from the Massachusetts Center for Contagious Diseases out of Beth Israel is the one that's heading up the studies.
And when they hire people to work at Deer Island, they do not ask what political party are you affiliated with either.
Well, I just
don't
wanted
know.
to bring that up because it appears that a lot of information that is on record with the Board of Health and any of our townspeople can look at it. I believe some people were forming opinions based on inaccurate information or not listening to what the Board of Health members had stated. So as for the record, again, not one of us were involved in the sampling that indicates the virus levels are reducing. So
And we'll always cite
leave
our
it at that
sources.
for now.
We'll always cite our sources.
Okay. So there'll be no meeting, no emergency meeting at Tewksbury Board of Health tomorrow to go over COVID numbers. Contact tracing update.
So with the COVID numbers going down, the contact tracing, we're still actively contact tracing as best we can. However, the schools now are opting into the new DESI protocol that came out yesterday, where schools will be sending home all staff and students home tests that they can take before they come into school. And it's my understanding they get 2 tests every week. If they feel symptomatic, they can just test at home. And then they'll opt into pooled testing, which is a random sampling. And if they find a positive, they handle it that way. And that would stop majority of the contact tracing in the schools. So then school nurses can get back to their regular duties.
Perfect. And food.
Does that mean the teachers can go back to teaching too? Yeah.
Hopefully. And then the food
You
consultant.
one would think.
Right.
I would hope.
And food consultant.
So the food consultant is finished. I'm just waiting for a few reports sent over to me, and then it's going to be back to the department, going back out into the food establishments throughout town. And the intent with adding Vincent through the grant is to increase the amount of inspections we do at our food establishments each year.
So he's already up and running too.
He's
Or ramping
training right now, so
Okay.
once he's fully trained, he'll be out there in the field.
Okay. One thing I wanted to just review tonight, I emailed it out earlier today and I left printouts here for board members. I guess I was not aware that the town had a remote participation policy that went into effect in 2012 and before I was on the board. So it was never in my welcome package on the board, but I just wanted to let everyone know that this is here and simply states that in order for any town board to be able to meet publicly, there has to be a quorum present of in-person members. So we're a board of 5, which means 3 people need to be physically present in the stated meeting location. And that if, and according to the Mass Open Meeting Law, any board member that is not able to attend in person, there is the second page of that 2-page document passed out is an authorization to utilize remote participation. I'm not a fan of adding more paperwork to what we're doing, but in order for us to be in compliance with state law or meeting law, we need to make sure that moving forward, that when someone is not going to be able to attend in person, that they do fill out that form and submit it to me, and then I'll sign it. And then I also need to read into the opening of the meeting a statement that a member is not going to be present in person, that they've authorized to join remotely, and the purpose for that. And they listed whether it's personal illness, personal disability, emergency, military services, and geographic distance. And the intent of the unwritten intent of the policy is that this is to be the exception to the norm that I think when this was originally written, it really helps meetings and the smooth conducting of business within a public meeting to have members there to deliberate face to face. And where we're coming off of the COVID and the WebEx meetings, moving forward, just because we had a bit of confusion tonight, we'll be very clear when a meeting is in person. So our monthly meetings now are in person. If we have to hold an emergency meeting, as long as we have WebEx capabilities, then I'll look at utilizing that, because then we can more easily join that meeting from where we work. But at this point, our monthly meetings, like for every other board in town, are being held in person. And we need 3 people present in order to meet. And if anyone's not going to be able to, they just need to let me know whether they're going to be absent or whether they're going to use the remote participation form, because it's, I had to cancel the December meeting last minute because I realized there was not going to be enough people here physically present to constitute a quorum.
Mr. Chairman?
Yes.
This paperwork, is this now not, this is pre-Jason, right?
Yes.
WebEx?
Yeah.
Wouldn't the Jason move now put this in the circular file? We would have to verify through WebEx, that we're going to be remote and so on and so forth. Why do we even need to do this anymore? I mean, we're either here or we're not, and if we're not here, there's a reason for it. Jason knows why. Why are we making more, or, keeping more paperwork for ourselves?
That's the open state meeting law.
Yep.
So by that, we have to have that form where the expectation is everyone's going to meet in person, and if someone's not going to be able to, then they need to essentially request permission to remotely participate.
Go
So,
through the chair.
yeah.
Okay. All right.
Yeah, so it's not
Also,
a Board of
please
Health
thank
rule, it's something I
Jason for
wrote,
the-
it just, and that is no reflection on how we've been meeting up to now. This is just, I wanted to start off the year, and now knowing that there's a regulation we should have been following, I just want to make sure that we're
Not in violation.
not in violation.
Okay.
Okay.
And that's within the confines of the United States border in the state of Massachusetts. So no, we're following all the rules. That's good.
I'll get you a copy of it, Tony.
He was emailed it.
Thank you.
Everyone got it by email today.
Well, I got to tell you, I was busy seeing patients all day since 7 o'clock this morning, so I haven't had a chance to review it, but I will take a look at it.
Okay.
But I also would like to say thank you for Jason to do that. I wasn't able to even acknowledge his rapid response to getting this WebEx because, as I said before, based on my logistics, it's impossible to do what I do and be back in time for 6 o'clock meetings. So thank you again, Jason, whether you hear this or not, for setting this up. And I will.
Okay. So I have. Oh, what happened there? Looks like everyone dropped off. Marie, you still there?
I only got an email that the meeting was being held via WebEx, which is why I'm here.
Yeah. No,
So
that's
I
right.
did not receive that document.
Huh. I'll send it again tonight, but any board members have anything else they wanted to add before I ask Mr. Rue for his motion? Well, Mr. Rue?
Mr. Chairman, I'd like to make a motion that we close tonight's meeting.
Second.
That was quick.
Any discussion?
Negative.
Hearing none, we'll put it to a roll call vote. Motion's been put forth by Mr. Rue and seconded by our board attorney. All those in favor signify by stating aye. We'll take the remote callers first. So Dr. Bichetti? Maybe he was one who had to drop off.
In that bad section.
Mr. Rulis?
Can they hear us?
All right, well, at least we still have majority here. Mr. Rue?
Yay.
Mr. Scarano?
Yay.
Chair votes aye as well, so motion carries unanimously 3-0. So
Very good.
good night, Tewksbury. It is 7:47 PM.